Hello, Rob Lambert here with AssetProtectionTraining.com. Today I have a helper. Her name is Biners. She's a midget cat, Cornish Rex, and she lives with me, and sometimes she comes in and helps. Okay, now back to work. I'm talking about coordinating your asset protection trust with your estate plan, and there's two different ways this is done. One way is a lot better than the other, in my opinion, but let me talk about what they are, and then let me show you how I suggest you do it. One way is to put all of the estate planning technology into your asset protection trust. It requires that your asset protection planner become also your estate planner. And that's not usually a good idea. First of all, your estate planner should be somebody who's close to you, who's younger than you, who's extremely focused on the limited issue of estate planning, particularly if you have any money at all. And right now, we don't even know what the rules are going to be because they're expiring, and we don't know if they're even going to have new rules put in place. So it's highly up in the air. Now, do you want to amend your irrevocable asset protection trust every single time the tax law changes? And the answer is absolutely not. The only people who suggest this are people who are either extremely close to you, qualified estate planners, and that means a lawyer with a lot of tax training focused in on your local jurisdiction. There isn't somebody in Florida or New York helping you if you live in Kentucky. It's somebody local, and you're not likely to find a great asset protection planner who's also your local estate planner. And also, many of them have confided in me after a few drinks that the reason they put the estate planning technology, which changes every year or two, into the asset protection trust is to hold on to the client, to force the client to come back to them, spend more money with them every single time. They want to add a kid, subtract a kid, make a distribution to somebody who maybe is injured. Anyway, any changes in their will or estate planning trust require that you gear up this expensive asset protection expert. That's foolish in my mind. I believe the better ways to do it are to use the provisions that I'm about to talk to. These provisions are based upon what's called power of appointment technology. And what these provisions do is allow your will or your estate planning trust, not your asset protection trust, allow your will or your estate planning trust to control the disposition of protected assets. This has two advantages that are important. The first one is you're not forced to amend your irrevocable asset protection trust on a regular basis. Every time you want to add a kid, exclude a kid, take care of a new wife, a new grandson, somebody with a disability. Every time you make a change, you have to change your asset protection trust, pay your asset protection planner serious money. The asset protection planner is very likely not from your jurisdiction, which means your planning will be inferior. And it's also really still requires that you have a local estate planner. It is always wrong in my mind, well, always is too big of a word, but it's almost always wrong to use a asset protection planner as your estate planner. They're two different functions, and your estate planner needs to be your personal general practitioner, like your personal doctor, like your family physician, while your asset protection guy is more like a brain surgeon if you're really doing it seriously. So separate the two. And I want to show you how I like to separate the two. This has been reviewed by many, many lawyers. They love it, and it uses power of appointment technology. Well, let's start with the first one, using a will to coordinate your asset protection trust with your estate plan. Now, this is a really simple provision here, and we can make it much more complicated. Sometimes it happens, but this does the trick. And I'm just going to read parts of it to you. Upon the death of the settlor, that's usually my client, the trustee shall distribute the trust fund. That's a defined term in most trusts. That means everything in the trust, to one or more of the beneficiaries on such terms and conditions as the settlor may appoint by an instrument in writing, including, without limitation, a will. This means that if you write a will and say it's my intention that this will control the disposition of the protected assets, the disposition of the stuff I put into my asset protection trust, and I want this will to control, it doesn't force you to go amend your asset protection trust every single time that the tax law changes. And you'll note there's a saving clause beginning with notwithstanding the foregoing. The trustee, with the written consent of the protector, there we go, this consistent theme that the protector is the naysayer, the policeman. Defer any distributions pursuant to such power of appointment if such delay would be necessary to protect the deceased settlor's account from claims of his or her creditors. And then talks about what the trustee does in the event of a delay. This fits in nicely with the provisions in most states requiring somebody with a will to settle with creditors quickly, or the creditors will lose their capacity to get the assets. This makes sure that your assets are not delivered to a creditor immediately if you die upon your death, if those creditors exist. I have seen some serious cases where funds were withheld in a protected environment to be distributed to the beneficiaries. It became a negotiating point in a couple of these where the money was just not going to come unless and until there was a settlement with the creditors. Again, game theory, another opportunity to settle. And the good part about this is that the beneficiaries, if there's a huge delay, can usually find a way to receive the funds without passing them into a jurisdiction in which the creditor can reach the funds. I don't like to play hardball like that, but this gives you the power. And sometimes you really do have to take out the baseball bats and go to war. This is a great tool if you want to have your will control your asset protection trust disposition. And remember, some people like their asset protection trusts to continue way past their death. This assumes you want to distribute your protected assets when you die. You have the choice to keep them in place for many years, usually way over 100 years after your death. Okay, I'm going to show you another typical provision that would control the disposition of assets in the event you had a estate planning trust. Most people with larger estates will have an estate planning trust that's funded in large part during their life and then completely funded with a pour-over will upon their death. And this is basically almost the same as with a will. It basically says that provided the settlor, that's my client, actually has an estate planning trust. And this is usually written a little bit fancier with very specific definitions and all of that, because the estate planner here is working with the asset protection planner to make sure that nothing falls through the cracks. That's part of funding. But that the settlor has actually settled an estate planning trust, directing that the estate planning trust control the disposition of the trust fund, which is a defined term, meaning the stuff in the asset protection trust. So this basically instructs the trustee to distribute assets in the asset protection trust pursuant to the terms as outlined in the estate planning trust. And it also provides that the trustee, with the written consent of the protector, again, always keeps creeping in, defer distributions if such delay would be necessary to protect the stuff from creditors of the settlor. And it works like a charm. It is absolutely a way to keep yourself protected, even from creditors after your death. Now, I want you to print these provisions out. They're in a PDF at the bottom of this page. I want you to read them a couple of times when things are quiet. I want you to think about what the repercussions are to you. I want you to think twice next time some estate planner, asset protection expert claims to be everything to all people. And do not hire a asset protection expert to do your estate plan unless this person is local to you and somebody you would have hired to do your asset protection plan anyway. In that case, it's perfectly fine, but he better be an expert. He better have some international tax training. He better know the asset protection world as well as the estate planning world. If not, you're getting cheated. I hope this was helpful, and I look forward to speaking with you soon in the next video.